I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I am bringing you compilation number 215. We will be in 3 different courtrooms for this compilation. Before I let you know what those courts are, don't forget to like, comment, share, and subscribe. Also, commentary will be left in where commentary was when these previously aired, and there will be chapters added for your convenience. Now, for number 215, we have 3 different courtrooms. The first courtroom we will be in is with Judge Joseph Rossi out of the state of Michigan. The second judge we will be with is Judge Thornton, I should say, Nicholas Thornton out of the state of North Dakota. And last but not least, we will be in the district court out of the state of Colorado. Guys, as always, it is a pleasure to have you guys join me here on the channel for another compilation. Listen, it's time to jump into 215.
Is Franthea Price, case number 25-05340AE. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court for a motion today, although it was not clear to me what the nature of the motion is. So as an initial matter, Ms. Price, would you state and spell your full name for the record, please?
I just want you to know, Your Honor, I'm here specially, not generally, and do so sui juris as the authorized agent for the family, Franthea family of the Price estate. So my appearance is strictly limited to the matter noted today, and it does not grant any joinder to general jurisdiction, nor does it have any waiver of rights or imply legal disability or association with any bar guild.
Well, I get it, Ms. Price. However, I can tell you that I'm a general jurisdiction court. I operate under the United States Constitution and the Michigan Constitution, and those are the only things that give me jurisdiction to act or make any decisions. So if you want me to decide anything in your case, you're going to have to be within the jurisdiction of my court. So, and we don't have to hammer that completely out at this time, but I do need you to state and spell your name.
Franthea, Franthea.
All right. Last name Price, Price.
I am.
Very good. And Mr. Bakikuo, would you place your appearance on the record, please?
Thank you, Your Honor. May it please the court. Stephen Buquicchio, Buquicchio, P number 62076, on behalf of the plaintiff preferred credit union.
Very good. And Mr. Bakikuo, this is not your motion. This is Ms. Price's motion.
It is, Your Honor, although like you, I'm a bit confused as to what the relief she's seeking here. So I'm prepared to assert preferred's position legally here, and we'll wait for the court's direction as to when I can speak on that.
Very good. Well, let me go back to Ms. Price, because it's her that initiated this motion appearance. What are you asking me to do at this time, Ms. Price, in a legal sense?
I respectfully request that the court take judicial notice pursuant to MRE 201B of the following 2 documents I previously filed into the court record. One is Exhibit J, OC 10, subpoena duces tecum, demand for custodial records. And number 2, supplemental notice of clarification regarding the constructive subpoena duces tecum. These materials, Your Honor, are supported by the Federal Reserve Operating Circular number 10, Appendix 3, UCC Article 8, subsections 8, 102A, 14, and 15, 12 CFR, subsections 225 and 31 CFR, subsection 203, which collectively...
Let me just pause you just a minute, Ms. Price. The one thing I recognized of everything you said there was the Michigan Rules of Evidence and the term subpoena duces tecum, meaning you're directing a discovery subpoena. Is that directed at Preferred Credit Union?
It is, sir. I also wanted it to be on record because I previously asked for debt validation and didn't get anything in the lower courts. So
Okay.
Your
Well,
Honor, may I respond?
yeah, go ahead, Mr. Mercutio.
A couple things, Your Honor. There's a lot to unpack there. Number one, we have a judgment in this case, so any attempt for discovery is outside, respectfully, the jurisdiction of this court at this point. I suspect what Ms. Price or the estate of Miss Price or the Franthea Price family of Price estate is seeking to do here, Your Honor, is undo the judgment that was legally entered in the lower court case. So I would just say, Your Honor, what she's asking for is irrelevant and outside the bounds of what this court can do. The case is over as far as the district court is concerned. I can get into the argument as to the debt validation. I did produce with our response a motion for summary disposition there that did provide for the debt validation notice. Ms. Price continues to mislead the lower court and now this court that a debt validation was not given. It was in fact given. This is a simple credit card case, and she is trying to use far-flung, just I can't even characterize what these arguments are, Your Honor. I want to be respectful of Ms. Price's ability to defend this in pro per, but
I object, sir. I'm not in pro per. I'm sui juris. Thank you.
okay, whatever that means, Your Honor. This is making a $12,000 credit card case so much more for my client, and Ms. Price, pursuant to the agreement, is responsible for those attorney fees. And I know there's a fine line between allowing a defendant in pro per or sui juris or whatever the name she's calling it, but this is just abuse of the process, Your Honor. She is alleging things that have no legal bearing whatsoever. She's asserting UCC, bill of cost, bill of ladings, bill of exchange, foreign bill of exchange. Your Honor, I don't even know what this means, to be quite honest, and I've been doing this for over 25 years.
Let me just pause you for a minute, Mr. Mercutio. Something I did see that I did recognize as I paged through the file was the affidavit of transcript of the lower court record, which is normally produced in a case that comes before me on appeal of the district court decision. Are you aware of a notice of appeal filed?
I am not aware of that, Your Honor. I suspect what was done here, Your Honor, was in the lower court. The judge indicated to Ms. Price that she's ruling in favor of preferred, and she was welcome to appeal that. And I suspect this is her attempt to appeal that. And to the extent Your Honor is ready to rule on her appeal and either, overturn the lower court's decision on the judgment or some other ruling here, I'm going to proceed as though she is seeking to undo the judgment that was entered against her. That's all I can surmise by this, Your Honor.
Yeah,
Okay.
if I may speak.
Yep, go ahead, Ms.
I
Price.
believe the opposing counsel has stated he has not received an appeal. I have sent that, all the information you received. He's received that. I have the record that the hard copy receipt from the post office. I sent this certified mail. So I do have the receipts of all of those things. Whatever you have, his office received it as well. I do have the proof of service and all that. The fact of the matter that he continues to mischaracterize this as solely a simple credit card debt that I'm trying to avoid, that is simply a mischaracterization of what I'm attempting to do, as is unsupported on the record that I've attempted through bill of exchange, and I've asked and requested and have not received a simple application. A copy of it is not supported of the verification that this is a bona fide contract. and lawful consideration, if it's not done, is violation of a contract as well.
All right. Well, you know, here's my where I sit on this one, Ms. Price, is that my position legally here is I'm the court of I can sit as the Court of Appeals to review the judgment in the district court. And what I appear to have in front of me here is a partial appeal, in that I do have the record, at least at what looks like to me, it's not a full record, it's just a transcript of the summary judgment hearing at the in the district court in Kentwood. Normally, when I get the record from them, it has a whole bunch of other documents that explain, you know, in a nutshell, how that case was reduced to judgment. And I don't have that, so I don't appear to have an entire record. And what I don't have from you specifically is a document called a notice of appeal that tells me that you're appealing a final judgment and that you want me to review that for its legality. I can tell you, because it is on appeal, it follows the appellate rules of the Michigan court rules, and they are, for lack of a better term, more intricate and harder to follow than the general court rules or the court rules for proceeding in the district court or in the circuit court. There are a lot more hoops to jump through on appeal, and that's really where you are when you're in front of me. And I can also tell you that on appeal, what I'm supposed to do is look at the record that was generated in front of Judge Sturkenberg, and you know, the new stuff that you file with me, arguments or you know, requests for discovery, Mr. Bequicchio is accurate in saying that normally you don't get any additional discovery on appeal. Normally what you do is you make an argument on what happened below, and that might include that Judge Sturkenberg denied you proper discovery, and that thus she made a legal error that warrants me overturning that case or sending it back to Judge Sturkenberg for more work or you know, things of that nature. And I can tell you from what I see in the file right now, I don't have the information I would need to decide that. So what I am going to do is direct you to file the requisite notice of appeal and appeal documents within the next 15 days, or I will dismiss the appeal, and you'll have to start that process over again, and the dismissal may have a substantive effect on your ability to file another appeal. So what I'm telling you is this appeal that's in front of me right now is incomplete. It's not documented per the appellate rules, which are found in the Michigan court rules. And, you know, I wouldn't have any choice but to dismiss it unless you supplement it with at least bare minimum a notice of appeal and you know, sufficient information to inform me and Mr. Bequicchio what the nature of your appeal is. What, you know, that it appears that you're appealing from a final judgment. However, all I saw in the final judgment, I think, was the fact that Judge Sturkenberg did grant that on the record. I didn't see. Do you have a judgment in order that you filed, Mr. Bequicchio, a written order in connection with that?
We do, Your Honor. A judgment was indeed entered subsequent to our motion for summary disposition and hearing on that motion, and I believe that was submitted with our response to Ms. Price's filing, whatever that was, Your Honor.
Okay, and unfortunately, I have Ms. Price's filing. I don't think that I have your response. It didn't make its way to me in time to come home with me for the file. So I'll review that as well. But Ms. Price, like I say, there is documentation and it is strictly required by the appellate rules. There's no way, you know, sometimes in the lower courts, a judge can say, well, you're appearing as a sui generis pro se, you know, a person appearing without an attorney appearing beside them, and I can give you a break on following some of the rules. That's not true at all on appeal. Appeal there, either you follow the rules or your appeal gets dismissed. It's you know, kind of a black and white system in that regard, and that it doesn't give me very much discretion when I'm sitting in that appellate jurisdiction. So you do need to get that in order, and I'm going to have it ordered that it be done within 15 days. And that's, I think, all we can do for today.
Your Honor, as a procedural clarification, Your Honor, to the extent Ms. Price does supplement her appellate filing and the court finds that it is inconsistent with the appellate rules, will another hearing be required, Your Honor, or is
No, I'll just sign an order of dismissal if I don't have the proper documents to initiate the appeal.
Terrific. Thank you, Your Honor.
Very good.
Your Honor, you said I have 15 days to get the information because I believed I sent all of this stuff in appropriately. I went into and handed it in and got the proper documentation. And the fact that you said you don't have that information is a little
Yeah, no, I do have a bunch of
about it.
stuff that you filed that appears to have been printed out by you. The one thing I have, you know, and the only suggestion I can make, Ms. Price, there is a legal assistance center on the 4th floor of the courthouse. If you talk to them and say, gee, Judge Rossi said I was missing some stuff on appeal, they can at least direct you to the proper forms to file to initiate an appeal. Because the one thing I did receive here, was the notice of filing of transcript and affidavit of mailing, and that's on a Michigan court form that I recognize. And what I then got was a transcript of that hearing, the last hearing, it appears, in front of Judge Sturkenberg. However, there is more stuff. They need to, what really they need to do is transmit the entire record of that case, or you as the party need to assemble that record on appeal, the record of what happened in the lower court, and get it to me on appeal. You know, and that basically looks like those transcripts plus any paper documents in the court file that happened in the district court. And I don't see any of those in my appellate file here.
They told me that I put there that they was going to mail it to you. They mailed me a copy and they said they was going to mail you a copy because I purchased the transcripts and everything.
Yep, and I did get the transcript, the one, but that's just the transcript of the you know, the hearing on appeal, and that is part of what I need. Well, and you know, I said I didn't have a claim of appeal. I stand corrected as I'm paging through here. And I have to tell you, Ms. Price, the filing of the, you know, the additional documents here, I know you believe it's important in helping me to decide your case, but I can tell you what it's doing in a practical sense is making it really hard for me to file, you know, just to track the documents that actually do trigger my duty to you know, decide stuff on appeal. So I do have a claim of appeal. Looks like it was signed by you on June the 13th of 2025. So really what I need on appeal then, and again, you know, I'm also prohibited, as the folks at the Legal Aid Center are, from giving legal advice. But I can tell you, if I'm to decide any appeal, I'll need a copy of the entire lower court record on appeal. And the record on appeal, like I said, it usually it's assembled by the parties to the appeal. Usually you, as the person, the individual appealing the decision of Judge Sturkenberg, are the one that's going to, you know, put that together. Mr. Bequicchio can contribute to that record if he wishes to do so. And then that gets submitted to me, you know, kind of as a, here's what happened at the lower court. It tells the story of that in those filings and pleadings filed at the lower court. And then you file a brief on appeal, and your brief makes the arguments as to why Judge Sturkenberg made legal errors in her decision making. And, you know, since I'm requesting that brief now, I just thought I was needing the claim of appeal. But since I have a claim of appeal that properly initiates the case on appeal, what I really need then is that record on the lower court. And then I need a brief from you explaining the errors that you think Judge Sturkenberg made. And I'll tell you, I will not be receptive to documents telling me that Judge Sturkenberg or I didn't have jurisdiction. That would be in effect saying, Judge, I'm arguing that neither of the courts could really decide this case because of my legal status, sui generis, or whatever magic words you're trying to invoke there. That just doesn't work. And the reason it doesn't work, particularly on appeal, is I have to have jurisdiction to decide the appeal in the first place. And if you're telling me I don't have jurisdiction, you're as good as telling me, as judge, dismiss my appeal because you can't decide it anyway. So in other words, you got to give me more than that. It's got to be an argument based on Michigan law as to what mistakes were made by Judge Sturkenberg in the court below, and then I can decide the matter on appeal. And since I'm looking for the brief on appeal, that's a little harder to put together along with that whole record. I'll extend the time for the filing of the record on appeal and your brief on appeal. I'll give you 60 days from today's date. We're at July the
25th.
25th. Yeah, sorry, my glasses. I'm using a backup pair of glasses because my regular ones are in the shop. So 2 months from today will bring us to September 25th to have those documents filed. And then I'll be able to decide those. And I'll also tell you, Ms. Price, the way it works on appeal is I don't need to grant. You can request oral argument, which would be another version. Today, really, this is more of a status conference. It's not so much oral argument because I couldn't make head or tail of what the file was asking me to do. You can request oral argument if you want it. I don't have to grant it on appeal. Sometimes I just review the record and the filings and, decide the appeal based on that. And of course, Mr. Bequicchio, after that 60 days, can file whatever he wants in response to your arguments on appeal. And likely that'll be a motion to dismiss the appeal saying Judge Sturkenberg did everything right and there's nothing to look at here, folks. So that's kind of how it works on appeal, just for your information. And like I say, if you need help with at least the forms part of it, the Legal Assistance Center on the 4th floor of the courthouse is a good resource for that.
Okay, so am I, just for clarification, because I'm going to do this right this time, this coming next time. There's 60 days you need a brief on appeal explaining the errors of the lower court.
Correct. And the record.
And you need a complete record of the two hearings that had taken place.
I need the complete record from the lower court, and that would start with everything from Mr. Bequicchio's complaint that he served you with and the proof of service and all that stuff. Typically, there's a copy of it. Would be as if you grabbed the file from Kentwood and made a copy of every piece of paper in it.
Okay.
Plus the transcripts.
Okay. Plus, you still need the transcripts as well?
No, you already filed the transcript. If that was the only hearing in the case, were there other hearings?
There were none, Your Honor.
Okay, so that was the only time that you two argued in front of the judge. So I don't need any additional transcripts. I just need the record on appeal.
Your Honor, there may have been a pretrial. I can't remember whether or not that was on the record or not, Your Honor. But if it is indeed on the record, the lower court record would include that, of course.
Very good. All right, so that's what I need, is that record from the lower court. Mr. Bequicchio, I think the appellate rules allow you to weigh in and supplement the record or collaborate on submitting the record to me. I'll leave that to you as to how much you're going to participate and assist with that production. But you two can talk to each other. The goal being to get everything in front of me that I need to decide the arguments that you make in that brief on appeal, which is where you get a chance to make your substantive argument as to any errors made by Judge Sturkenberg.
Thank you, Your Honor. I will say, to clarify from our position, we did respond to the filing of Ms. Price. With that, we included the complaint, the answer, and our motion for summary disposition, and Ms. Price's response to that motion for summary disposition. So that should make its way to the court file. I don't know whether that would be deemed an official record as far as the appeal is concerned with certified documents, but we did put the underlying materials in our response. So that will be contained in your file. And
Copy obviously went to Miss Price, so she should have received
yes.
all those filings as well. And yeah, normally, right, there is the certified record on appeal gets a simple one-page document from the district court saying this is everything we have in our file. So I would accept either way. If you want to supplement what Mr. Bequicchio sent Miss Price, or whether you want to just go to the district court and say, hey, I need a whole copy of that file because Judge Rossi is asking me for it, and it's got to be certified because it's on appeal. They at least have done that before down there at the Kentwood Clerk's office, so it'll at least give you a starting point as to what to do. And like I say, I think I'd make my first stop the Legal Assistance Center so you can walk in there with the right form when you go to Kentwood District Court.
Thank you. And then do I use the same case number as well?
No, it'll be assigned, and it already has been assigned a new case number on appeal, which is the one we're here on today. It's 25.
Yes, that number, that's the one I'm speaking of.
Yep, that is the appellate case number.
Okay,
Now, when you're talking to Kentwood and if you're looking for
It's
the
a different
district court
number.
record, then you got to
Yes.
go with that number down there.
okay, thank you. I appreciate your help, sir.
Very good. Good luck to you, ma'am.
Thank you.
Thank you, Your Honor. Thank you, Ms. Price.
All right, next cases the court's going to call will be State of North Dakota versus Michael Scott Jacobson, file 26, 2023 CR 36, 26, 2023 CR 16, and 26, 2023 CR 50. Present in court, Attorney Mary Depute for the state. I'm here by special appearance, executive. Please have a seat. Please have a seat. Mr. Jacobson is personally present and without counsel. Sir, good morning. Were you present in court when your rights were read to you earlier?
Sir, I don't consent to this hearing because of lack of jurisdiction of the court over me. I'm not a 14th Amendment citizen anymore. And it's in my documentation that no one ever reads.
Sir, I asked you a question.
I told you.
So,
I am not,
sir,
I'm not.
sir,
under your
stop
jurisdiction.
talking over me. I'm going to ask you a question and you're going to answer the question.
I don't understand.
So I'm asking you, were you here when the rights video was played not once, but twice this morning?
I was here.
Do you understand the rights as they were read to you?
I don't stand under anybody.
I'm asking if you understand the rights that were played for you.
I don't understand.
Okay, so let's talk about what you do and don't understand, sir. Do you understand the English language?
You do not have jurisdiction over me. If you look at the documentation,
Answer my question, sir.
you do not have jurisdiction over me.
Answer the question, sir. Do you understand the English language?
I don't understand.
Okay, so I'm asking you if you understand the English language.
I don't stand
So-
under anybody.
Sir, I'm asking you if you understand English. I asked the question in English. You responded in English. I think you
What's
understand,
your answer?
but I'm making a record, sir, to make sure that we're clear.
My record is you don't have jurisdiction over me.
And,
I'm not a 14th Amendment
Sir.
citizen or resident.
sir,
You even know what I've done? I've changed my jurisdiction. I've gotten out of the jurisdiction of the water and I'm back on the land where
sir,
I'm alive. I'm a living, breathing soul. And you cannot contract with me anyways.
yeah, I'm not contracting with you at all. I'm asking you if
That's
you
what this court is trying
Sir.
to do.
Stop talking out of turn. Are we clear? I'm asking you, do you understand the English language?
You've answered that already.
So your answer is yes, you understand.
You answered it.
I'm asking you to answer it, sir.
You've answered it yourself.
It's not for me to decide. It's for you to put on the record whether you understand the English language or not. Do you understand what I'm saying to you?
I don't stand under anybody.
That wasn't the question.
We're not going to get anywhere. You do not have jurisdiction over me.
Sir,
If you had read If you would read my affidavit,
Were you present in court when your rights were read to you earlier?
I've been in court many times. And I've heard those rights.
And so you understand those rights?
I don't stand under anybody.
That wasn't the question. Do you
That's what you're
understand?
asking me to do. I don't stand under you.
Sir, you've already said you made a special appearance. So I'm asking you if you understand. Do you understand?
I comprehend them.
Okay, comprehension is good enough. You comprehend them. All right. Do you comprehend that you have the right to an attorney?
I don't need an attorney.
Do you comprehend that you have the right to either an appointed attorney if you financially qualify for one, the right to hire an attorney of your choosing, or the right to represent yourself if you can do so knowingly, voluntarily, and intelligently?
I don't consent to this hearing because I'm not under your jurisdiction. I'm
Sir?
under the jurisdiction of the land.
I
Not in the
understand.
jurisdiction of,
Sir?
of your contract law.
Okay. Do you comprehend your rights to an attorney?
I don't need an attorney.
Has anyone threatened you, forced
No one has
you?
threatened me.
So let me finish before you start talking. Sir,
I've been here the last 7 times.
stop.
Nothing has happened. Read the
Stop,
file.
sir. Stop interrupting. Stop trying to talk over me. I'm asking you a question. Has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive your right to an attorney?
No one has.
Thank you. So we are here today for a number of dispositional conferences. A dispositional conference is a conference set to determine how you intend to proceed.
Your Honor, if I could interject, I'm sorry, but I think there's a little more complexity to this procedural posture. In case 16, the defendant had filed a motion to dismiss. The motion to dismiss, a response was filed with the state on June 28th. At the last status conference, the defendant wished to raise the same motion in all 3 of his cases. At that time, it had not been served in the 2 remaining cases. Although the motion still has not been served, it has been filed in the 2 remaining cases. And so I believe that there is a pending motion before the court in all 3 cases.
So this wasn't noticed as a motion hearing. Rule 3.2 requires that the moving party file a notice of motion declaring whether or not the motion is to be heard for oral argument, to be heard for an evidentiary hearing, or to be considered under briefs. That notice of motion wasn't filed, requesting a hearing. So today it's not properly before the court, even if it was properly served.
I brought it to the clerk's
Sir.
court. I could not get a hold of Ms. Pugh. She would not
So,
return my
stop.
calls.
This is where I'm talking. So those motions have not been served. So technically, even if the state's filed a response, they're not ripe for the court's consideration. So the court is not going to take up motions. Furthermore, these are Judge Naram's cases. I'm not going to rule on motions in Judge Naram's case or cases that are not properly before the court and noticed for hearing. So as far as the court's concerned, all that's before it today properly is a dispositional conference. Sir, you have 5 options at a dispositional conference. You can schedule it for a jury trial. You can request a bench trial. And if the prosecutor agrees and the court agrees, the court can schedule it as a bench trial. You can request a continuance. You can change your pleas from not guilty to guilty today. Or you lastly can choose to schedule a change of plea for a later date.
Well, let's do a continuance until Judge Naram gets the case so he can make a decision on it.
All right, so what I told you before is right now, those issues aren't properly before the court because they haven't been served properly following the
We'll
rules.
serve them properly. We'll just do a continuance then.
All right, Ms. Depute, your thoughts?
That seems appropriate to me. I believe at the last, maybe there are not notes on the docket. I believe it was contemplated by the previous judge that this would be a motion hearing. It was discussed at that time. The state is ready to proceed. But if Your Honor doesn't wish to hear it today, then I believe continue it until Judge Narum could hear the motion would be appropriate.
So, okay.
Could you make a decision before you even go back to trial? I suppose I have to file that.
Yes. So Judge Narum's next court date in McIntosh County is 6 weeks away.
That'd be fine.
It's November 13.
We can't get nothing done if there's another judge here. Gotta have Judge Aaron.
Well, he is assigned to these cases, and typically once a judge has been assigned, unless there's an agreement or stipulation between the parties, I'm not going to sign a motion or consider a motion that wasn't on the docket as a motion hearing. So I will continue this matter, all three matters, for a dispositional conference and a motion hearing for November 13 before Judge Narum. It'll be set at 9:30 a.m., but I'm sure Judge Narum will call that case last. Just so you're aware of that. Mr. Jacobson, it probably will be late morning before that motion is heard. Ultimately, Judge Narum will be able to decide the motions, assuming that they are properly before the court at that time. And so that means proper service, proper notice of motion. You'll need to file a 3.2 notice of motion that declares whether it's for evidentiary hearing purposes, oral argument hearing purposes, or both. And at that time, Judge Narum can make decisions. So that'll be the decision of the court today. Continuance in all three files until November 13 before Judge Narum at 9:30 a.m. Anything else, Ms. Depew?
To clear up part of the record, in case 16, it was noticed as a motion hearing. I understand the judge's ruling. I just want to make sure that what's represented is correct. But other than that, I have no further comment.
Yeah, 'cause I remember him telling me to file motions for the other three, put them all three on the same date.
Yeah. So as a matter of judicial economy, even if it was, it's not an odyssey. The code that I was looking at isn't an odyssey saying that it was a motion hearing. But the notice of hearing document does say and motion hearing. But in the Odyssey record, it just says misdemeanor dispositional conference on file 16. On the others, it has not been cleared up. So in the interest of judicial economy, those will track together if it's the same motion in all three files. So, all right, with that, we're adjourned in this matter. Thank you.
'26 CR 921 Trammell appearances.
Daniel Cohn on behalf of the people. Mr. Trammell is present
Pro se.
on bond, pro se. Looks like last time we were in court, he was asking for extra time to potentially hire counsel.
I had, on April 6th, I indicated to you that you should apply for the public defender's office. Did you do that?
Yes, ma'am. No, I did not.
You qualified?
In that time, a lot's transpired.
Okay.
Did you get the notice that I submitted into the case?
The letter?
Yes.
Did you get it, Mr. Cohen?
Let me check real quick. Yes, I do see that.
So your, did you have first and foremost, I'll indicate to you that I am not an administrative law judge.
Okay.
All right. But it looks like based on what you were asking in here is that you're asking for restitution. That is not something that can be done out of this case.
Okay.
All right.
Okay.
And you're invoking a number of other,
Yes, I mean, given the nature that there's no injured party or no damage to property, I have a concern with an administrative court hearing
I'm not an
judicial matter.
administrative court.
You're not, this is not an administrative?
No, this is part of the judicial branch. This is
an
not part
Article
of
3
the,
court?
excuse me?
This is in Article 3. We're in Article 3 court.
This is not an administrative court.
Are
This
we
is
in an
a
Article
part of
3
the-
court?
I mean,
That's just a simple question. I'm not trying to be difficult. I want to know what I'm walking into before
Your Honor,
I'm not trying to be difficult at all.
I would just ask
Given the
that,
nature of what's going on here, I need to know exactly what I'm,
so last time we were in court, this court agreed to continue, but said the court would expect to move forward on this date. At this point, the people would just ask that the court enter a not guilty plea on behalf of Mr. Trammell and set it for a disposition date. It sounds like Mr. Trammell has some philosophical beliefs about the system that don't exactly match with the facts of his situation, but that's neither here nor there.
objection.
You're citing the United States Constitution, and we're governed here.
Absolutely.
I'm appointed by the state. So
Absolutely.
this is not a federal court. This is a
But the-
state court. So no, this is not an Article 3 court. This is a state court. All right. This is not under the United States Constitution. I am not appointed. I wasn't nominated or confirmed by any federal body. This is a state court. So
Yeah, but
no, this is
did
not
you
a.
take an oath to the Constitution? And are these state rules repugnant to that oath? That's the only question I
Yes,
have.
yes, there are state rules, and you are charged in this case with having a dangerous weapon, possessing a dangerous weapon, and having a large capacity magazine, which is prohibited. That's what you're charged with under the state law. So how do you want to move forward? You don't have an attorney. We're currently set for a appearance of counsel, so let's go ahead and set this for arraignment.
Set for arraignment?
Yes, so at that point, or you can do that today if you'd like. Plead
No.
guilty, you can either reach an agreement or you can enter a not guilty plea. Do you want to enter a not guilty plea?
No, I do not.
What do you want to do today?
Set this for another arraignment. I need more time to figure out what.
So why don't we come back next Friday at 8:30, and at that time, it'll be set for arraignment. All right?
Friday?
Friday, the 29th.
Can we do the following Friday?
That's the following Friday is the 5th. Do you have an objection?
No objection.
June 5th at 8:30,
Thank you.
and that'll be for arraignment. Great.
Thank you, sir.
I'm not threatening you. Say one more word and that's 30 days. 30 days.